Welcome all back from that breathing break of the afternoon. I hope you did have a good breath. In any case, now we don't have to put on the masks unless you're sitting in big groups in front of the screen. So excellent to have you all back. Welcome to the panelists and to the moderators of the previous sessions who I've just asked to join us also with a brief intervention. We're coming to the concluding plenary panel of a very rich day, and obviously I was not able to jump all from one to the next working group sessions, so I did, as you know, participate in the morning and participated in one of the working groups, and I hear from colleagues that there was very active and interactive discussions going on. So I think now the time towards the closing of this conference to see what do we take with us from here. What's the lessons learned, and not necessarily also, but not necessarily only, say, for environmental issues, for corruption issues, for communication issues, and so on, but really what are the general lessons that we can draw from this day, and how can we go forward from here and help enhance the collaboration, the connectivity between the regional and the global human rights mechanisms. We have discussed that today in a lot of different aspects. As I said, first starting out with seeing how the mechanisms themselves cope with COVID restrictions, both in their working methods, but also in addressing the human rights challenges that COVID and COVID responses have brought with them. We had then also a plenary panel on the complaints handling by the human rights mechanisms, and we saw, I think, there are a lot of points that we can pick up again in this session on what the different mechanisms can actually learn from each other. The working groups explored corruption and human rights, again, the links between the global and the regional mechanisms, but a lot also, I think, without having been there, but I'll hear about this, probably the links between the human rights mechanisms and the anti-corruption mechanisms. Environment and human rights was a working group too, and we'll hear also from the moderator on how the mechanisms address the link, and I think there too, including the participants in the panel, had a very active roles in the respective mechanisms, played active roles, so I'm sure there is a lot of proposals coming from that one as well. The third working group on universal and regional human rights mechanisms dealing with international humanitarian law. Well, there I had the privilege of having read the background paper, so to speak, so the research that was done before at the Academy. But I'm sure also from looking at the list and from the discussions we had earlier that there's lots of very practical examples and ideas how to go forward. Building Back Better finally was the working group I attended, looking at the rights to health and housing. And again, there, the human rights dimension in COVID responses were extremely pertinent links of human rights system with other parts of the UN system, but then also to regional mechanisms. So now for this concluding plenary panel, I'm thrilled to have an excellent panel with me. So if there are people who can tell us how to go forward, how to explore more connectivity there on the panel and in the audience, I would add. So let me briefly introduce them before I give the floor to the moderators of the working groups to brief us on some outcomes. So speakers in the plenary panel are Julia Mottok, who is judge at the European Court of Human Rights and professor of European and International Law at the University of Bucharest. And Ms. Mottok is, as I said, judge since December 2013, but previously she also served as judge at the Constitutional Court of Romania. And previous to that was a member and a president actually of the UN Human Rights Subcommission on Promotion and Protection of Human Rights. So has this experience in the UN mechanisms, where she also was at the time a UN Special Rapporteur for the Democratic Republic of Congo. Christoph Haynes is director of the Institute of International and Comparative Law in Africa and professor of human rights law at the University of Pretoria, but also a member of the Human Rights Committee, and in this capacity has worked on a lot of the texts also by the committee, including the general comment on the right to life, but also has worked with the African system, where he also contributed to the drafting of the General Comment 3 on the right to life in 2015 of that regional commission. From 2010 to 2016, he was a UN Special Rapporteur on extrajudicial, summary, and arbitrary executions. We have also with us Solomon Ayele Derso, the chairperson of the African Commission on Human and People's Rights. We're very pleased to have you with us in this session. Dr. Derso is a adjunct professor also in the School of Law at the Addis Ababa University in Ethiopia, and chair of the Working Group on Extractive Industries in Africa, and executive director of Amani Africa Media and Research. And as I mentioned already in the morning panel, we are honored to have also again with us Joel Hernandez Garcia, president of the Inter-American Commission on Human Rights, since which he joined as a commissioner in 2018. And as Mexican diplomat, Commissioner Garcia was also ambassador to the OAS, where he chaired a working group on the strengthening of the Inter-American human rights system. And in the morning plenary on the communications, we had already quite some insights from you, which I think relate also to that role, and which maybe lend themselves to draw conclusions and also good practices for international mechanisms. And while I'm not seeing her with us at the moment, in principle, Margaret Makulai would also be joining us soon. She is also commissioner in the Inter-American Commission of Human Rights, but we also invited her as she is a former judge of the Inter-American Court of Human Rights, where she contributed to the formulation of the rules of procedure of the court. So we will see, my colleagues will see whether it's any technical issues that for the moment prevent her from joining us. But as mentioned before, giving the floor to the speakers who I just presented, I would like to call in the order of the working groups on the working group rapporteurs to highlight some of the issues that they heard in the working groups. So again, I do not want to ask you to give a full report of your working group. That's not the purpose of this panel now, but just maybe the few points that could be generalized in terms of how the connectivity, how the cooperation between regional and global human rights mechanisms can be enhanced in your working area. And what would be the points that you'd like to make sure to also insert into that concluding panel? And with this, obviously, into the report of recommendations that we at the Geneva Human Rights Platform will do from that meeting to take on into further work. And so if I could actually call on you just in the order of the working groups, I would start with Patrick Mützenberg, then ask Emily Max, then Lucy Maxwell, then Milon Kotari to give input in what the working group, sorry, not Milon Kotari, sorry, Virginia, yes, so you both had interacted so much in that, so sorry, Virginia Vash Gomez as a moderator of the working group before, to bring in some of those points. So first of all, Patrick, over to you.
Thank you very much, Felix, and good afternoon to everyone. I was indeed pleased to have the chance to moderate the first working group on corruption and human rights, and how those regional and global human rights mechanisms can actually be engaged in the fight against corruption. So it was a very interesting panel. We had 4 excellent panelists, and it was a quite technical working group where we address the issue of corruption both at the national level with 2 panelists who actually just reviewed some concrete cases and how they were litigated at the national and some of them at the international level, and 2 other panelists from the international level to really discuss how corruption is actually addressed by the international level, the UN treaty bodies, and also the regional system, and also in the context of the UNCAC convention, so the Convention Against Corruption at the UN level. I think the main point of discussion that we actually discussed in that group was first, and all participants actually agreed on that the lack of linkages between what we call the Geneva system or the UN treaty bodies or the UN human rights mechanism at the UN level in Geneva, and the Vienna system, which is the system that actually encompasses the UNCAC Convention. I think this lack of linkages between the two systems, the two pillars, not only from the mechanisms themselves, but also in the context of those who actually engage with those systems, and in particular the civil society, was something that was quite clear and obvious for all the participants. And we actually had discussions to see how we can improve these linkages and how we can try to develop bridges between those two systems. And I think that's extremely important to have more linkages in those those two pillars, to have more concrete recommendations. I think most of the panelists agree that, for instance, the human rights machinery, or in more particular the UN treaty bodies, address more the issue of corruption. So it's more systematically addressed in, for instance, the reporting reviews of the UN treaty bodies. But now there is a need for more concrete recommendations, and those recommendations can be more concrete only if the anti-corruption groups actually engage more with the UN treaty bodies. And at the reverse, it's the same with the Vienna pillar, where the human rights based approach is extremely weak, and as long as we will have no more NGOs working on the human rights environment engaging with the Vienna system, this will remain a big challenge. And finally, I think there is also an interesting discussions on new emerging issues on human rights and corruption. And one was the sexual abuse in the context of corruption. Some questions and quite long discussions on how those new emerging issues like the sextortion was or was not addressed in the Vienna system or in the Geneva system. And it was interesting to see that those new developments are not yet addressed, and it will certainly take time for more engagement on those issues. And again, here, the civil society from both anti-corruption community and human rights committee would have a leading role to play to make sure that the various stakeholders at the UN level will be aware about those new developing and emerging issues. So that's where the main highlights of the panel. And again, it was extremely interesting and with very thorough discussions from all the participants. Thank you, Felix. The floor is yours.
Thank you very much, Patrick. And I will not comment if we have questions to you and the working group members. Actually, the participants later will come back to that. Let me hand over directly to Emilie Max, please.
Thank you so much, Felix. Good afternoon, everybody. I'm very pleased to be able to give you a snapshot of the discussions we've had during working group number 3 this afternoon. We've had diverse panelists from NGO, the International Commission of Jurists, from academia, the University of Essex, from an international organization, the ICRC, and then from a human rights treaty body, namely the Committee on the Rights of the Child. So the main takeaways from this afternoon discussion was that when human rights mechanisms, be it universal, so UN treaty body mechanisms, or regional like courts, address issues of international humanitarian law, sometimes they do so but stay silent on certain sub-issues, especially when it regards detention in non-international armed conflict. And it's hard then for practitioners to know what to do with the silence. Is it a silence that is on purpose? Is it a mistake? And how can that silence be filled remain the questions. And examples were given, especially again with regards to detention in non-international armed conflicts, with the general comment number 35 of the Human Rights Committee and the jurisprudence from the European Court of Human Rights on the Hassan case. Then we also realized that mechanisms can draw from each other's practices, but it's usually regional mechanisms that draw from the practice of universal ones, and the reverse is not true. So it's important to increase cooperation in that regard, an exchange of information between mechanisms, but not only with regards to the jurisprudence when it's been out, but also while it's also been written, would be ideal. There were questions about can outsiders like ourselves at the conference today really comment on connectivity between mechanisms, or is it something that has to be done behind closed doors between people who are already inside? And then other takeaways that I found were very interesting. The first one is a reminder that human rights mechanisms can only, and especially courts, can only pronounce on violations of international human rights law and of the treaties that they're bound by, and that they can only draw from international humanitarian law to do so, but they cannot pronounce a violation of IHL per se. And then when those human rights mechanisms deal with IHL, what is IHL? Or they're dealing with only conventional rules, but also customary ones. Those I thought were interesting questions. And then with regards to what can be done, one panelist mentioned that for universal mechanisms, it would be interesting to consolidate guidelines on state reporting, especially with regards to the optional protocol on the Convention on the Rights of the Child, because it's a human rights instrument that contains also rules on dissemination of IHL for all states, so also in peacetime, not only states affected by armed conflict. And then a couple of other things. One panelist mentioned her wish that regional courts, but also universal mechanisms, would be aware of IHL and have IHL knowledge, not as, you know, a legal framework that is similar to human rights, but have a knowledge of IHL in the way that military lawyers would interpret it. And then she also highlighted that a little knowledge is a dangerous thing. So it's important that even if there is IHL knowledge within human rights mechanisms, it's important that those mechanisms be cognizant of the limitation of their own knowledge and of the differences between the frameworks. And yeah, I think that's it.
Thank you very much. Thank you, Emily, for that recap. And it reminds me also when we heard in the morning plenary about the African Commission being able to look into other international documents. So let's see what can be explored on that. Let me hand it over directly to the moderator of the working group on environmental issues. So Lucy Maxwell, please, Lucy.
Thank you, Felix. And I'll keep the remarks short. Again, like the previous working group, we had a really wonderful array of experience on the panel, a committee member from the UN Human Rights Committee and a lawyer from the Registry of the European Court of Human Rights. So they were able to speak about their institution's engagement with environmental protection and human rights. And then we had two representatives from civil society, one from the African Network for Environment and Economic Justice, and another from the Centre for International Environmental Law, and finally a perspective from academia. And I think some of the observations that came out of the discussion was just the huge explosion in norm development by both regional and international human rights mechanisms on states' obligations to protect human rights by regulating private actors and ensuring environmental protection, and really mapping developments in the last 2 to 3 years that have changed the landscape. And I think there was a real sense of momentum and excitement about the amount of work that's happening at the UN level and the Inter-American system and the European Court of Human Rights. And then really asking ourselves how, as people engaged in these different institutions, we can promote the dialogue between them and ensuring that both the judges and tribunal and committee members look to each other, and also that litigants are aware of what to draw upon when they're bringing cases and communications, commencing at the national level, but also we talked about a number of communications before UN human rights treaty bodies that are on foot, and some that are pending. And in terms of sort of positive reflections of dialogue already happening, the UN Human Rights Committee member emphasised how much they look to developments in the European human rights framework and the Inter-American. And then interestingly, the lawyer from the Registry of the European Court of Human Rights mentioned a twinning program that had happened with the Inter-American Court of Human Rights. And that's quite a deliberate means of facilitating that knowledge being shared between lawyers working within those institutions. And finally, I guess looking to the future, the UN Human Rights Committee member emphasized how important civil society's contributions are in drawing to their attention developments that are happening in different systems. And I think where we ended was looking at taking one environmental issue being climate change, that before UN human rights treaty bodies and the European Court of Human Rights, there are now 4 new novel pending communications that those institutions will have to grapple with sort of almost simultaneously in the next year or so. And that might be one thematic issue in which those institutions might want to have quite a deliberate form of knowledge sharing and discussion on the common issues that those institutions will face when adjudicating the claims that are now going to those bodies on questions of science and standing and that kind of thing. So we left it with that sort of view to the future on the topic of climate litigation. So I'll leave it there. Thanks.
Thank you very much for having filled us in on the discussions in your working group as well. And now for the fourth working group, I'll hand over to Virginia Brash-Gomez, moderator of that group. So if you could, Virginia, also give us some insights from your working group, please. Virginia, you're still muted. Sorry, Virginia. Yes, now.
Unmuted. Thanks very much. The panelists in our working group were Robert Louis Lettington from UN Habitat and Natalie Robbins from Robel from WHO, and Milun Kotari, who holds a number of hats, but I think here I could identify me as being from UPR Info, because that was one of the points he raised. So of course, the main theme was the indivisibility and interdependence of human rights, in this case, particularly health and housing, to deal with the pandemic, but more importantly, in the recovery efforts, which means attention needs to be paid not only to immediate responses, but rather to longer term interventions. There were plenty of examples from my colleagues on how health and housing policies with a human rights approach are mutually reinforcing. But also we were very aware of how inadequate housing conditions in deprived neighborhoods and the lack of access to goods and services were at the heart of increased infection rates now during COVID. So there was this call for healthy housing policies and also for housing to be considered as an important entry point for intersectoral policies. I think there's some theoretical understanding of this, but in reality, on the ground, this doesn't happen very much, and it would be a very important step forward. So what fundamentally states need to do in terms of indivisibility is to make long-term investments in public health and comprehensive social protection programs, decent work, housing, food, education, water and sanitation. And this is an area where global and regional human rights mechanisms have a strong role to play, because they could monitor how states generate and allocate maximum available resources, in particular for those most in need of protection. And some of the ways to do it that were highlighted in the group were to have more assertive structural and process review of government policy, including legislation, implementation, planning, budget, etc. To have clear support to national human rights systems on benchmarks reviews, and to pay greater attention to global and regional trends. There was also this issue about how important international solidarity was in the recovery efforts, and how global and regional human rights mechanisms can be powerful advocates to promote universal access to the benefits of scientific advancements relating to COVID, such as medicines, vaccines, etc. Regarding the response by the UN as such, there was positive appreciation about the response from the UN having been robust, right from the Secretary General to the High Commissioner, to the treaty bodies that have issued statements. Reference was made to the statement from CESC, which calls for targeted measures, including through international cooperation, the special rapporteurs on housing that have made also a number of recommendations. But there was reference to one mechanism, which is UPR, which is at this point in time probably the only fully functioning mechanism, since the human rights treaty bodies and the special procedures are very much restricted in discharging all their mandates, but that UPR is probably the only fully functioning mandate at this time, only functioning mechanism, and that it has probably not been optimally used in terms of COVID, or not in terms of COVID, but that states have not been providing sufficient information on COVID, and they should be encouraged to do so, as well as to provide examples of best practices. I'll leave it at that, and thank you very much.
Thank you very much, Virginia. And with this little briefing of the working groups, I would like to start now with the panelists of the concluding panel. Sorry to have you made wait, actually, but I think like this, you got the gist of the day. And so thank you again for that update to all the moderators. And I'd like to invite the panelists to both actually react to the points that you have heard, if you have been participating earlier or now from the moderators, react to the points that come out of the conference, but also share your more general views on the topics as laid out in the concept notes on where we are currently in terms of the connection of regional and global bodies. What lessons can be learned from contrasting different practices of the one bodies to the other bodies, and how to ultimately maximize impact of global and regional human rights system in their mutual support, and how we can also ensure greater connectivity about all those components so that we actually could at one point in time speak about global and regional level really as a system. So we heard that in the keynote in the very beginning from the director of the Fundamental Rights Agency, Michael O'Flaherty, saying we like to talk of it as a system, but we're not really there yet. So how to go further with this? With this, I'd like to invite first Julia Motak, please, to share your thoughts with us. Ms. Motak, please, the floor is yours. And sorry, you're still muted.
Muted.
I'm not muted. Hello to everybody. I'm very happy to be here with you. And a lot of thought, because I was listening in the morning, not in the last panel that were summarized. And I think that from the perspective, I will talk today, despite the fact that previously I was also a member of the Human Rights Committee. So 7 years, so a very important body with individual complaints and so on and so forth. I will try to talk today more from the perspective of the European Court of Human Rights. So I think that if we look to all this question that are raised by the connectivity between the universal and regional, the main thing that I was listening, because there were a lot of colleagues that were involved in litigation between these courts. They were question of kind of choosing one of the mechanism that had a better result for the individual. What we call here to be what we call from very long time to be forum shopping. So this is something that I don't know how to see this phenomena. If you look to this phenomena from the international law point of view, of course, you call this phenomena of fragmentation. You are thinking at the end of the day what you are going to do, what the states are going to do, where they are confronting with two different interpretation. And we have a very famous one, a very famous case that was completely different, resolved by the Human Rights Committee and by the European Court of Human Rights. And so the Portuguese government, it's Correia de Matos versus Portugal, came back to the European Court of Human Rights, asking us what they have to do if the Human Rights Committee on the individual complaint, same individual complaint, it's a case about a lawyer who was dismissed for different reasons. The same case was considered to be a violation from the point of view of Human Rights Committee, and was considered to be inadmissible from the European Court of Human Rights. And so the European Court of Human Rights kept with a very small majority, 8 to 9, but dates that they kept the same, we kept the same view. So it means for us it was still a non-violation. So in this respect, we are thinking from the point of view of litigator, but you have to think also from the point of view of the state at the end of the day, what the state is going to execute when you have divergent case law between international body and the European body. And here we don't have that. It is a case that norms are sometimes different, but here is not a case where the norms were different. The norms were completely the same. So this is, I think, a question that a very concrete and very abstract question, what to do and what the state, especially because the litigator will find the best one, but what a litigator will do as well, because he can win in one body and he can lose in other body. And this is of course is an incentive for connecting more the two organisms, the regional and the international. But sometimes it's simply not possible. So the connectivity sometimes is not possible for reason of keeping the case law, for instance, in our case law, and for reason sometimes of small legal difference between one body and a regional body. So I think it's something that we should reflect, and the problem was raised a long time ago, and since I don't see what is the resolution of this body. We have to say that we have several other cases where the decisions of the Human Rights Committee were taken into account by the European Court of Human Rights. Here it's, for instance, Batayan versus Armenia, where we speak about the military service for the conscience reasons, and initially the court was not accepting this as a violation, and finally, following the Human Rights Committee, it was accepted. Another case where the court was really open to Human Rights Committee offending are Margaret Helsinki versus Hungary, where the court took in Article 10, freedom of expression, previous interpretation of the Human Rights Committee in the freedom of information. And another case, it's Baka versus Hungary again, which is the dismissal of the judge of the Supreme Court in Hungary. And again, the Human Rights, the European Court take into account a lot the case law of the Human Rights Committee. And to link to one of the theme that was the theme of corruption, for instance, and to think, because as former member of several UN bodies and lastly Human Rights Committee, of course, especially when we had the reports on country, we have a lot of mechanisms that emphasizes corruption in one country. When we are in the when we are at the European Court of Human Rights, and I think this is it's a very, very important topic of nowadays. But the question of corruption and the relation with the human rights. And but when you look at the European Court of Human Rights, what we can do is either to look of the cases where there were a violation of several rights, procedural rights, or they were not in the context of punishment for corruption, or to look, for instance, what we have the case regarding now my own country, Kövesi versus Romania, or the actual prosecutor of the European mechanism against prosecutor against corruption. So the actual chief of this EPPO mechanism, former prosecutor general and former prosecutor anti-corruption in Romania, was dismissed by the government, who was against, of course, of her point of view about corruption and so on and so forth. So these are quite, I think, for the time being, these are the mechanism what we can do to deal with the dismissal of judges that were involved in the corruption cases, and because they are involved in the corruption cases, they were afterwards dismissed with different pretext. Otherwise, but we don't have we don't have, for instance, other cases that we can really have a topic like this in our court. Another, because they started with I jumped for the idea to another, because they started with the COVID one. I have to say that the court has already several cases that were not yet communicated regarding the COVID-19. They will be communicated very soon, but and the main issues here is that, you know very well, in our court, as for the Human Rights Committee and other individual complaints, and we have the non-exhaustion of domestic remedy. So we are going to see if really it was it was enough time that passes, and the individual that came to us with the complaint of COVID-19, they were really they exhaust domestic remedies, or they have the domestic remedies to be exhausted. Another theme that I will not talk about here, about I will talk shortly about environment. It's true that nowadays we have at least 4 or 5 cases that are connected to environment, they are connected to climate change, they are going to be communicated. And at the court as well, I think 1 week ago we had a conference about environment. So we have a range of cases in this domain, but not enough yet. Very interesting is also the theme of international humanitarian law. And here I have to say that the court was a little bit reluctant to apply international humanitarian law for a very long time, because they were not norms of the convention. So we found a kind of competition again between the human rights norm and humanitarian law norms. But recently we had this case that our colleague that made was the moderator made. We have Hassan case, and Hassan case really versus United Kingdom. It was a full range of taking into account the norms of international humanitarian law. So from it's a very recent case. It's a case for 2014. So we see an evolution of the court in this domain. So I will stop here. Maybe I will intervene afterward. Thank you very much.
Thank you very much. Thank you for also all the links to our substantive panels and working groups. And I think also when you mentioned your conference a week ago on environment at the court, I think there too it was an example, if I recall, of also connection, as the High Commissioner, the UN High Commissioner was speaking there. So I think those are also issues that we see being dealt with by the different mechanisms at the same time, where it might go to the General Assembly also to see about that recognition of a right to environment. So I think that again are great examples. If I may turn now to Christoph Haynes to share his views as a Human Rights Committee member, but also with the other affiliations that I mentioned before. So Christoph, over to you, please.
Thank you very much, Felix, and good day from Pretoria to everyone. Very happy to be part of this. I have two sets of issues that I thought I should address. First is perhaps just two conceptual issues, and then a number of practical matters, instances of connectivity which are existing but which can be improved. So first, the two conceptual issues. The first is the relationship between regionalism and regional systems and the universal system, and how does that affect the universality of human rights? And I think that depends on how we see universality of human rights. Often universality of human rights is seen as simply that there's one set of rules that's made applicable to everyone, and that's in a way, if it's seen on its own, that's in a way top-down, because the question is, who decides what these norms are and the ownership of these norms? So I think if we see universality of human rights as, yes, there are certain rules which are applicable to everyone, but everyone has a role in determining what these rules are. So that's the broader approach to universality. And in that context, I think regional systems play a very important role. They are a platform for participation in setting up what those norms are. If I think about my own continent, if African countries on their own had to only operate within the United Nations system, then like the other regions, they will be outnumbered. And it's very difficult then to have an impact. But there's a system in Africa, there's a system in Latin America and so forth. And that's a platform where closer to the ground, there's ownership of the system. So it seems to me that if we talk about connectivity, it's important to keep in mind that yes, there's a top-down element, but there's also a bottom-down element. And it's important to connect to the regions, but also I would see connectivity as going even further and the notion of universality also to the domestic level. If we talk about international or about a human rights law system, then it's really the universal, the regional and the domestic which come together. So the first point I want to make is that I think regions play a very important role. And then the second point is just on the contents of the term international human rights law. We often see that people say on the one hand, we have international human rights law, and then we have the regional systems. And I think that implies that the regional systems are not part of international law. So from my perspective, international human rights law includes the global or the UN system and the regional ones as well. So those are just the two conceptual issues, first issues. Perhaps to move to more practical issues and as I mentioned, to some extent, good practices, but practices which I think can be improved. And certainly there's room for many more as well to enhance connectivity. The first one on my mind is really because we're in session in the Human Rights Committee at the moment. And yesterday we were preparing for our meeting with the upcoming meeting with the Inter-American Court of Human Rights. So we had a meeting last year with the European Court of Human Rights, which I think was very useful. Judge Matok was there as well. And then we were going to have one with the African system in July, which because of COVID didn't happen. We hope that that will happen soon. And then next week we'll have a meeting, a virtual meeting then with the Inter-American system. And just in setting up the agenda for that, we looked at COVID, for example, on the substantive, that's our proposal to them, that we look at how we respond to COVID on the substantial level, but also on the practical level. How do you run a human rights body in a time of COVID? And I think to me, that's an example of connectivity, exchange of ideas between the UN and the regional systems. Then the second one I want to mention is the drafting of new instruments and the collaboration that takes place there. And again, I think there's much room for improvement. But in the recent General Comment 37 that the Human Rights Committee drafted on peaceful assembly, for example, we interacted a lot with the regional systems. So the Inter-American Commission had adopted guidance on this. The African Commission has 2 soft law instruments on this. And the OSCE, of course, over many years has worked on this particular topic. And so, for example, members of the Human Rights Committee went to Warsaw, and we met with the OSCE there. And also we had members of the African Commission, Solomon, for example, also engaging in our own internal discussions. And earlier in 2015, there was the drafting of the General Comment 3 on the Right to Life of the African Commission, in which a number of us were involved. And again, it was to me a good example of collaboration. In this particular case, yes, the UN was involved, but the point that I remember very well, in fact, at the Geneva Academy, we had a meeting once the draft was ready. We met in Rwanda, and then we came with a draft, and we invited the various regional systems on a thematic basis. So there were people there from the Inter-American system, the African system, also from ASEAN, OSCE, and so forth. Thematic specialists, people work on the right to life. And that was a collaboration between the thematic specialists then to look at this particular issue. And to me, that was in contrast with some of the other meetings that we sometimes have in the Palais de Nation, where there's somebody representing this or that system, and it's very superficial. This I found to be very helpful. And also because of this collaboration that we had in drafting the general comment of the African Commission, there was also then links that build up on the personal level, because at the time I was rapporteur on extrajudicial executions for the UN, who the person is in the Inter-American or other system that works on this particular topic. And so a number of things resulted from that. And that brings me to the third practical point that I want to emphasize, and that is that sometimes it helps to have some structural changes to facilitate connectivity. Again, just drawing from my own experience, when I became rapporteur on extrajudicial executions 2010, I had no counterpart in Africa in terms of a working group or a special procedure with whom I could engage. The closest was the one on the death penalty, but of course that leaves out all kinds of things such as police brutality and so forth. So we met with them. The African Commission then changed that mandate to be the working group on the death penalty extrajudicial executions. And that gave me a counterpart. And because of that, it was possible to work with a person in the African Commission. And later on, when we had a commission of inquiry of the Human Rights Council in Burundi, then we invited her along as one of the members of the commission as well. So I think many links are built through these thematic engagements. And also, in the meantime, that working group has extended to also include disappearances. And so the link, there was not such a mandate before in the African system. And now the link between the UN and the African system is much clearer also on disappearances. And so last week they had a meeting that looks at drafting a soft law instrument for Africa within the African system on disappearances. And that's within that particular working group that it happens, but they also draw on the experience of the UN and others, and redress was guiding that. The fourth point I want to make is about 10 years ago, a number of us in the UN Special Procedures met in Addis Ababa, again with the African Commission. That's mostly my point of reference. And we then drafted the Addis Ababa roadmap on collaboration between the African Commission and the UN Special Procedures. And that roadmap it's still active, and over the years it has resulted in joint visits. Certainly while I was rapporteur, we had joint press releases as well, and collaboration on a number of fronts. And I believe there's a similar structure for collaboration between the special procedures of the UN and the Inter-American system as well, which was more recently formed and is not as active, but that also creates a link between Geneva and the Inter-American system then. The fifth point I want to mention is the idea, and I heard it being mentioned earlier today in the discussions, the idea of regional meetings of the UN Human Rights Treaty bodies. So that's the idea that at least on occasion, the various UN human rights treaties will meet outside Geneva. This is something which I saw for myself the first time with the African system, because they meet in different parts of Africa. And this idea is also taken up in the treaty strengthening system. And of course, the Committee on the Rights of the Child has met in Samoa. And I think, again, this is a way in which the universal system comes closer to the ground. There's more ownership, there's more visibility. And even if it's not directly engaging with the regional human rights systems, it's within the region and it brings it closer to the ground. So it brings the bottom up element as well. And that seems to be taken on board now in the process, and it will be interesting to see how that develops in the future. The last point I want to mention is the one of that there's a study ongoing with the Office of the High Commissioner for Human Rights on measuring the impact of the UN human rights treaties on the domestic level in all 193 UN systems, UN member states. And I think impact and measuring impact is going to be increasingly important to show the relevance of the system. So this project is developing, they are using an algorithm, and the idea is to be able to say, for example, earlier today they talked about the impact of the Human Rights Committee's decision on abortion in Ireland, to track exactly how does the system have an impact on the ground. Now, my point there would be that I think this will give greater visibility and greater understanding and engagement with the UN treaty system, but we need something like that also on the regions. And this is the typical sort of thing that researchers, university institutions and others can undertake, but I don't see that the systems will thrive as much as they should if they cannot actually show the impact. So that may be something interesting as well, to see how, in parallel to the UN one, one can develop regional mechanisms for impact, and also to see how one can integrate these studies so that it doesn't have to start from scratch. I thank you very much.
Thank you very much, Christoph. And I think you've been very much on the side of what Michael O'Flaherty also called the achievement side of actually that collaboration and connectivity. And it was great to see that whole list of examples where connectivity, where cooperation is really bringing fruits and is going on. And so indeed, looking jointly into follow-up to common norms is definitely something that we'd also be very interested in picking up further on. Let me turn now to the two presidents of the commissions. So first to Solomon Ayele Derso, the chairperson of the African Commission on Human and People's Rights. So Mr. Derso, the floor is yours.
Thank you very much for the kind invitation that was extended to me. Great to join you this afternoon, at least in Addis and in Geneva, I suppose, as well. I think the theme of this conversation is a very important theme. I would say on account of the fact that human rights in general face a very serious challenge in the time that we live in, both from state actors, but also from non-state actors as well. And we are in a time when the support for human rights, even in parts of the world that are considered to be traditional champions of human rights, is proved to be wanting. Given the contemporary pressures facing human rights in the age of populism, nationalism, and various other forms of bigotry, including racism, I think the discussion and conversation about strengthening, finding leverage from the different systems of human rights is extremely important, and indeed it's a necessity of our time. I wish to indicate that some of the examples that Christoph used have also been in my mind as I was preparing for this session, but I wouldn't repeat that. But as I start off, I wish to also ask the question in terms of discussing about connectivity, whether the question of connectivity actually assumes what kind of power dynamics and power relations exist between the global and the regional systems, and how that power dynamic also affects in terms of how human rights from the perspective of the global system are perceived and seen, and what, if you like, why it is important and indeed imperative to have a regional mechanism and system of human rights. And this speaks to the first conceptual point that Christoph also spoke about when we talk about universalism. What is it that we are talking about? Who makes the determination in terms of what is universal? But the point being that the regional mechanisms can also be a site for enhancing the universalism of human rights without universalism being considered as implying sameness and being one, all right? So basically the question would always be, what is the minimum level from which we shouldn't go down? I think it is there that the question of really the role of regional and international institutions come in. The other issue, I think, to my mind in terms of interaction between the universal and the regional is whether there is a two-way traffic whereby the conversation is between the universal and the regional in such a way that not only the regional human rights system looks up to the universal system for inspiration, but also the other way around as well. The universal system actually looking to the regional system and taking from the regional system to enrich, if you like, the global system of human rights. Those 2 points are very important. Now, speaking from the perspective of the African human rights system, particularly the African Commission on Human and People's Rights, from where I come, just to quickly indicate, the Commission engages in receiving individual communications, individual complaints. On the basis of that, it adjudicates those communications. And as part of the adjudication process, I think you find very strong legal basis within the African Charter on Human and People's Rights, which is the founding treaty of the African human rights system, which actually authorizes the African Commission to draw inspiration from international law on human and people's rights. As you can see, we speak of not just international human rights, but human and people's rights. This is one of the distinguishing features of the African human rights system, which the system actually prides itself in saying it brings a very important dimension to the realm of human rights. So if you look at Article 60 of the Charter, it actually gives authority to the Commission to draw inspiration from international human rights law. And in adjudicating communications, the Commission invariably draws inspiration from the jurisprudence of institutions such as the Human Rights Committee. It draws also inspiration from the regional human rights system, the European human rights system jurisprudence, and from the Inter-American human rights system jurisprudence in that respect. So you find a lot of interesting stuff in that respect. So most recently, we addressed one case relating to freedom of expression and denialism of genocide. This was in the context of a case relating to Rwanda. Obviously, this led us to study the European human rights jurisprudence relating to denialism of the Holocaust as one important source of jurisprudence to look into this particular issue, for example. So this is at the level of the individual communications system. I think there is a lot that can be said in that respect. I think I wish to indicate here that, speaking in respect to the issue of international humanitarian law and human rights, the African Commission actually seeks to draw on and apply international humanitarian law, and it has been doing this quite for some time, with the recognition that there are variations in terms of the standards, but at least context determines how the Commission interprets the African Charter using the standards of IHL for purpose of adjudicating particular cases. I think other than that, the other point that I wish to make relates to the Commission also has a mandate, as Christoph indicated, to develop soft law instruments by way of a general comment, by way of guidelines and principles. So we have those instruments, model law as well. Of course, as part of this, there have been instances in which the Commission also developed legal instruments, treaties on specific areas of human rights, such as on the rights of persons with disabilities, for example. And in this respect as well, in drawing up these guidelines and principles, as well as general comment, at one level, using the expertise of the global and the regional systems. That is how the process happens. This consultation can happen, for example, when the Commission convenes its meeting, or when the special mechanism of the Commission invites a member of a special mechanism of the UN. We have very, I would say, much more regular engagement with the special mechanisms of the UN, particularly at the level of the special mechanisms of the African Commission, the example that Christoph gave illustrates as well. That is, a level at which these developments happen. It's not always a case of connectivity, obviously. There are instances in which some of the instruments that are developed at the level of the Commission obviously reflect specific needs and context-specific responses for the realities on the African continent in terms of human rights needs, which actually could be a very interesting source of inspiration that can be tapped into. I think there is a lot of potential there in terms of the global system taking from the regional system in that respect. One area that I can quickly mention, for example, relates to transitional justice. The African Union broadly, other international organization, adopted a transitional justice policy by the African Union heads of state and government at the summit level in February 2019. I had the privilege of drafting that policy, and some of the experiences from the region provided a lot of rich normative depth to how transitional justice have been articulated within the framework of that transitional justice policy of the African Union. which can indeed inform the conversation around transitional justice at the global level. A couple of points and then I will stop there. One relates to the institutional relationship between the global and the international, the regional. With the African Commission, we have, Christoph mentioned, the Addis Ababa roadmap with the special mechanisms. But in 2019, we also signed a Memorandum of Understanding with the UN High Commission for Human Rights. Within that framework, of course, we exchange information between ourselves and the UN system and other manifestation of making this practical. In the context of COVID-19, there was a joint statement that we have issued, myself as the chair of the commission and the High Commissioner for Human Rights on COVID-19, of course, in the African context. Another thing that I'll mention and end there relates to the conversation between the regional systems as well. Again, in the context of COVID-19, the Inter-America Commission convened a conversation between the African Commission, the ASEAN Commission, and the Inter-American Commission on the 12th of August to discuss about some of the questions relating to how did the systems respond, how are they also adjusting to the realities of not being able to meet in person and to undertake missions. I thought that was a very useful experience beyond and above some of the examples that Christoph gave. Thank you very much.
Thank you. Thank you very much, Mr. Joseph, for that list of areas of connectivity, actually. And I would like to hand over directly also, as we are in the interest of timing, also to Joel Hernandez Garcia now. You had been mentioning in the morning in the panel also, we spoke about communications and how the Commission dealt with or is dealing with its backlog. Now also, again for you, what are the ideas that you could see the global system, in that case the UN system, picking up maybe from your Commission, and what are ways forward to strengthen the collaboration? So over to you, Mr. Hernandez.
Thank you, Felix, and I say hello to all panelists. Let me be very brief on some general reflections from what I heard this afternoon and what we discussed in the morning. Three very short comments for the sake of time. One has to do with a universal view of human rights. The second, I want to address question relating to institutional cooperation. And third, I want to talk about election of members of human rights bodies. First of all, I am one of the persons who think that it's rather difficult to find a universal view of human rights. And probably we should not fall in a false dilemma of the fragmentation of international human rights law. I think every system, either universal or regional, has its own specificities, and they respond to circumstances and stakeholders which have created those systems. What I think is important is to advance the broadest protection of persons on the basis of the principle of non-discrimination and the principle of equal protection of law. What I mean is that in the Inter-American system, we have benefited a lot from many reasonings from universal bodies, regional bodies, treaty bodies, which with their jurisprudence in interpreting human rights law in an evolutive manner. I think all systems have in common an evolutive approach to human rights. Human rights law has to be progressively advanced, and in doing so, the Commission has benefited a lot from the rulings of other universal and regional bodies. But this is only for the purpose of the Inter-American system to provide the highest level of protection. I do hope that in return, the findings of the Inter-American human rights system can also serve as a source of law to other bodies. Second, what is also a practical matter is to advance on institutional arrangements, as President Ayele Derso has just mentioned, in order to benefit each other of the good practices that have proved useful in our systems. For instance, the panel where I participated this morning was dealing with procedural backlog. And I think there are very good, well, first we do share a common problem with backlogs. And I think we all have gone through different approaches. So for that, institutional arrangements are very necessary in order to exchange good practices. Institutional arrangements will also provide a good arena for cross-fertilization in order for regional and universal bodies to exchange their views on law and practice, on application of international law principles, but also on the development of soft law. And for that, it is important that those institutional arrangements can be strengthened. We have a memorandum of cooperation with the African Commission, as President Ayele Derso has mentioned, that was signed, if I'm not mistaken, in April 2018. Later, December 2018, we also have a roadmap with the coordination of special procedures. And we also have a memorandum of understanding with the Office of the High Commissioner. Now, those provide a good basis for cooperation, but we have to do more because so far we have the legal framework, but it's important to put that legal framework in practice. And in the past, that required financial resources, time availability for members of the different bodies to travel. Now, one of the things we have discovered with the pandemic is the possibility to reach out through this mode of communication. So now it's the time for us to make a better use of this discovery and to put in practice the legal framework that we have already established for institutional cooperation. The Commission has still to do more on international cooperation. For instance, with the treaty bodies, we only have ad hoc cooperation meetings. We don't have a general framework. And we are going to hold a meeting next November 10 with the Subcommittee on Prevention of Torture. This is going to be the first time that the both plenaries of these bodies meet, and I think this is important, but so far has been only an ad hoc meeting, actually under the initiative of the subcommittee. And we can institutionalize that practice in order to exchange the good parts of our work, and not only that, the challenges that we are facing, it is important. Finally, I think member states have to look into the composition of the human rights bodies in two moments. At the moment of putting forward a candidature, and second, and very important, the election of the members, of the future members of the human rights bodies. And for me, this is the cornerstone of the good functioning of a human rights body, because it often happens that the the candidacies are put forward by member states, we don't think very much on the needed credentials for the required post. And at the same time, the member states then go to elections, and they don't take into account the personal capacities of the candidates. And at the end, the human rights body depend very much on the work of its members. And for that, one of the things that candidates should be looking into is about precisely what we are talking about. Candidates should have a view of the future of the human rights bodies in light of the difficult circumstances that human rights bodies are now facing. This is a key question to know what's the view of the future of any proposed candidates. And I'm saying this because in the Inter-American system, 2021 is going to be a very important year. In that year, the Commission has to select its new executive secretary. In addition, the General Assembly of the Organization of American States will elect 3 out of 7 members of the Commission and 4 out of 7 judges. This is going to be judges of the Inter-American Court. This is going to be the largest election process in the history of the Inter-American human rights system. And we are at a crossroads. So it's very important to know what's the view of the candidates in order to select the best in the candidates in order to continue the strengthening of the system.
Thank you very much. And this last point of yours also resonates very much with what has been mentioned today, also in relation to the co-facilitators report of the treaty body strengthening process, where I think also one of the big salient points is the question about nomination and election of members to the treaty body system. So I think there you definitely have another point of connectivity. Now, I did ask via the chat to everyone to send in questions, and so you can still do that, but also there would be the possibility for people, if you'd like to speak, to request the floor, and even in this setting, we can give the floor also to other attendees aside of the panelists. So please do make use of that if you want now, because I think we'll just, in the view of the time, we'll just carry over this concluding plenary into the closure of the conference. So I'm trying to really wrap up the conference with this very session. So I'd like to invite you, your reactions to the points raised and any questions that you might have to the panelists, to flag your interest to speak now. I am checking the chat for the moment. I think there is no question on the chat. So also to all the participants, if you would like to speak, you can actually flag that to me via chat, and we can give you the floor to intervene in that session. Maybe just one smaller question while we are waiting, if other people from the audience are asking for the floor. Another practical question, one question that came up here to the presidents of the commissions was also, we talked a lot about the connectivity between the global and the regional human rights systems, but you also made mention just now also, both of you, of the joint statement by regional courts, or the connection between the different regional systems. So I was just wondering, is there also at what level would you see, is there the connectivity between the regional commissions, between the Inter-American and the African Commission, for example, in terms of picking up on each other's soft law development, and also the normative development, as you're obviously not, you're not in the situation as with the UN where you deal with the same countries, but with similar sets of rights. And so I was wondering, is there also something, and that goes also evidently to you, Judge Motok, for the European system, how much are you picking up also in the soft law development towards something that could be considered then some universal, well, a development towards universal jurisprudence, but also universal view in that sense? I don't know if any of you three would like to comment on that. Yes, Julia Motak, please.
Thank you very much. So I think my colleagues, they put a lot of philosophical question. I graduate also philosophy. What is the universal human rights, and the relationship is, especially I think the president of the African Commission of Human Rights put one question that it's fundamental. As I was in Africa, as you say, I was the rapporteur in Congo, so I was several times, I was there several years there. I think you know that it's very important for us as the regional system, because European is also a regional system. A regional system to, I will explain you why I said this, to have connection among us. And we had a meeting with the Inter-American Court of Human Rights. We have, and I am leading this, we have a structure at the court which is dealing with the connection with international courts and also with the national courts, all the national courts. So I think that it will be, for me, for instance, it will be very interesting to have a meeting with the Commission or the Inter-African Court, because this will be fantastic for us. But we didn't manage for the time being to get the right connection with them. Otherwise, we tried, and I said we had this network to have as much as relationship between among regional groups. And I have to say, and here I try to answer to unfortunately, I found, being so long in the UN, I found that sometimes the influence of the, and we know this issue, the influence of the European, of the bodies is more European that openness to the other. So I think that if you have a vision about, because you're talking about members and others, if members have a vision, I think members, and not only members from Africa or for South America or for other, they have really to see how they are going to bring more case law, more of these courts and the commissions into the universal system. And for us as European Court is how we are going to bring all this development. We have a section in our judgment where we make several reference to these systems, but maybe they are not enough apply when we go to the legal reasoning. Thank you very much.
Thank you very much for that intervention. Mr. Hernandez, Mr. Derso, would you also like to come in on that point?
Well,
yeah, please.
I think we all agree on the importance of having these exchanges between regional among regional bodies and also universal and regional bodies. And President Ayele Derso mentioned something which the Commission has been working very closely together with the African Commission, and that has to do with COVID. COVID was, as we all know, a very unforeseeable situation that where we have to develop very rapidly a set of recommendations for our constituents. And for that, the meetings that we hold with the African Commission were very helpful, because we were able to look into a mirror and to see what they were thinking on addressing this problem, the tools that they were developing, and at the same time, the opportunity for us to explain the things that we were doing. I think we have many tools at our disposal. We have one common problem, which is to make sure that all sanitary measures are applied with full respect to human rights. But in order to achieve that, it is important to know which are our strategies. So this is just to mention one example on how these communications are possible. And another level of communication is what George Motok has just explained, and that is the importance of talking, of having a judicial dialogue among courts in order to study together their jurisprudence, their decisions. But as I said before, we need a plan. If we have the plan, if we have the legal framework now, it's important to implement it. It's not easy. It's easier to have the plan than implement it. And many times we have wished, for instance, to have joint in loco visits with the UN special rapporteurs. And that has proved to be very difficult because even we have conflicting schedules or the recipient state does not allow to have joint missions. So it's very difficult to carry out, but it's important in order to have this connectivity, this cross-fertilization, and basically advance the highest standards of human rights protection. The microphone.
Sorry. Thank you very much. Thank you. And if I may turn to you, Mr. Derso.
Thank you. I think much of what I would have said have already been said by Judge Motoka and Garcia. So the only thing that I wish to indicate is basically it is about finding, for example, from our own experience, there are certain areas of work in respect of which both our system and the global system, or our system and other regional systems, may at the same time be engaged in. So in the development of certain standards, for example, if around the same time there were the process that's unfolding in our system, and there is a standard that have been developed or that is being championed by another regional system or by the global system, that gives you the platform to do actually something together concretely. The example that Christoph gave in terms of the General Comment number 3 on the right to life is a very interesting example. And putting it the other way, when the Human Rights Committee also developed its General Comment relating to the right to assembly, then from the side of the African Commission, you can have the standards that have been developed to provide insights and participate in that process. So identifying these areas and sharing experiences, sharing our jurisprudence, using those specific processes, I think would give a great deal of value for all participants, I would say. I think that's a very important one. Otherwise, in terms of working as a system, I think the only question would be, would you have the same emphasis or areas of focus at a particular time? So at a particular time, it's possible that certain issues become very salient and very prominent in the global system that may not necessarily be very prominent and salient for a particular regional system at that particular point. It may be other issues that may be salient and prominent. And in those moments, obviously, issues can arise in terms of whether the regional system would join in for those issues or basically would stand by and say we may join you some other time on that issue. So I think, yeah.
Okay, thank you very much. So there is a question just came in through the chat, and if I see it right, it's about communicating to the public professionals the more general contents of issues dealt with in communications. But I also would ask Ms. Aleve-Mina to ask the question yourself if you wish. Would just give you the floor. So if you'd like to come in and pose the question yourself to all, please do. And I'll have another question later for Christoph Haynes, which will relate to the Secretariat's function, the Secretariat's role in strengthening that connectivity between the mechanisms. But so if I can turn the floor to the question, please.
Yes, well, I'm a writer, so I'm much better at formulating questions in writing. So my experience is that having seen how things work in a given area, when I look at the propositions of law, so-called in Switzerland is like Vernehmlassungen, the consultancy that the government is asking if people accept as texts of law in the future, I can see what they relate to, but I know that the people who have not been in situations that I have had a chance to see will not understand what that actually means. When these texts are implemented, what will ensue, what will happen after that. So I was wondering, I mean, because when we look at things that are happening, we look at the communications that have been done in that area. We haven't personally been in the situation where the people have been. So how do we compensate for the lack of relevance, I guess, of our own knowledge?
Thank you. Yes, so thank you very much for the question, which then can go back again to all of you, because I think if you were referring to Swiss law, it obviously goes to any law, and also the interpretation of law more generally by the commissions or courts. So how can we communicate to broader public to understand what actually the meaning of that legal text would be in a more practical context? So that might be a nice challenge for you for the concluding remarks. I will go with this actually now in our last round of, if you wish, some concluding remarks. And Christoph, as I said, there was one question more for you, which is about the role of Secretariat, relating, I think, also to what Julia said before, like in terms of to which system, which regional system US treaty body members would be pointed at in terms of jurisprudence to look at. So I think very often, and it was mentioned also in the morning, there is a big role for Secretariat in preparing cases, but also preparing decisions, preparing the background materials. And I assume that for judges in other systems, it's a similar situation. So the question of how much are you pointed to jurisprudence by regional bodies to actually allow you to make that connectivity, that connection to them without doing all the research yourself. So how present is that in the day-to-day work of a human rights committee member?
Yes, thank you very much. And if I may, just one or two other questions as well. But on the issue of, because in practice you receive drafts, and so on the issue of drafts that you receive from the Secretariat, it's largely focused on the UN. I think there are a number of reasons why it's like that at the moment, but that should change. But I think one of the reasons why it is like that is the shortage of personnel, and then to have people who really know the regional systems, because limited knowledge may be indeed dangerous. And it may be the easiest, for example, to find the material from the European Court, but that may eventually not be balanced. And so once you start with that, it is quite a process to do. So I understand the concerns, but I think it also reflects the structural shortcomings within the UN. The UN is very unrepresentative, for example, or just to mention one example, Africa. And that means that very, very few people there with the necessary background to actually do that. And in the context then of, for example, drafting a general comment, for example, that's not done by the Secretariat, that's done by the rapporteur. But there was also, you may have seen in response to General Comment 37 on Peaceful Assembly, there was a whole discussion in the various blogs about our citation of regional jurisprudence. We started doing that with the last General Comment 36 on the right to life. And we cited various regional sources, and we continued in 37. And there were some people who said we should not do it at all. And then, of course, there was criticism that we were quoting, and they gave us the numbers, too many European court cases. So we did cite a lot of the soft law instruments of the African Commission, for example, the Inter-American documents. But that's again quite difficult to do, because if you have, for example, a case from the African Commission which cites the European court, then the question is, do you now cite the African court which cited the European one, or do you go to the regional one? So there's almost a built-in bias in the system which would need to be changed over time. But I certainly think we should cite regional jurisprudence with all the complications that it entails, because the system is one as a whole. And then if I may, to Alevis' question about how do we get our message out, and how do we, as I understand the question is, how does one make it understandable, not only for lawyers, but for others as well? I think that's important on a number of levels, even in the drafting of the documents. And if you look at the Human Rights Committee, with which I'm most familiar, it used to be quite technical. With the last general comment, we used the approach of plain English. So we took out Latin references, no discrimination against Latin, but that does make it more difficult. And we use phrases in the original document that we thought would be more understandable. But then also actually just this week, the office issued a question and answer sheet, which we drafted together with them, which makes it even more accessible. And then, of course, one of the most important things if one is talking globally is the translation of these documents. And so the general comment on Peaceful Assembly, for example, has been translated now into French and came out today in Arabic, and it's coming out in Spanish next week. Because if one really wants Latin America to use it, for example, it must be out in Spanish. The UN is not always the quickest body in the world. And so with some of the other instruments, it's taken 2 years to have it translated. In this particular case, it was July, and now it's coming out in October, hopefully. So that, as far as I'm concerned, is a record. And then the question of, so Solomon mentioned joint visits, and Mr. Garcia as well. Just my own experience in Burundi in 2016 was a joint visit as rapporteur on executions of the UN with a member of the African Commission. And I must say it was a positive experience in terms of our collaboration. There was also a third UN special rapporteur there. So the three of us, the visit was very difficult, but the collaboration between the three of us was very good, but largely also because we know each other from before. We knew each other from drafting the general comment on the right to life. And so in terms of identifying the relevant person, that was also good. I think things can go wrong if you have a joint visit and you have, for example, in a region where somebody is from the region who may be more sympathetic to the government or less sympathetic, whatever the case may be, things can go wrong. So one should not be naive about it. But if it goes well, I think there's more legitimacy in having this sort of global and regional collaboration there. And then if I may, just the last point is, I'm personally very much convinced that the most value is to be gained from thematic cooperation between regional bodies and the UN system. These very broad ones about how does your system work and that kind of thing, it's good up to a certain point. But the most important thing I found was that if on a particular topic, on a particular right, for example, you know who is the point person, and you have their phone number, you can WhatsApp them, you can email them, You can have a discussion with them and say, I want to issue a press release, or I'm involved in this or that. I'm looking for somebody to join me there. Can you advise me? And I find that to be extremely helpful when it's thematically driven, because then you speak the same sort of language. And I've found that to be something that that I think is very valuable. Also, if the structural differences are there, are addressed, so you don't have a mismatch of mandates, but that they deal with the same kind of issues, and then you have your counterpart. And well, just one very last thing still, if I may, the one, where do the regional systems have an impact on the global one, and not the other way around? And again, I think that's very important if we want a bottom-up kind of approach to emphasize that. And I know with many of the other regional systems, and the one represented here, the European Inter-American one, there are many examples of that. But I can certainly say from Africa's side, with the general comment on the right to life, there was a sense of urgency to finish this, because we knew the Human Rights Committee, I wasn't a member of it then, we knew the Human Rights Committee was going to do one on the right to life. So we wanted to get the African one first. And indeed, it became a reference point, and it's quite often quoted in the UN one. So for example, on the issue of the death penalty, that there must be a progressive abolition of the death penalty. It doesn't only come from the African one, but that was supported by the African one, and that then found its way and it's cited in the one of the Human Rights Committee. And also this idea of regional meetings, as I mentioned before, this is an idea that came from I saw it the first time in the African system 20 years ago. We started arguing for that, and then over the years I saw the Inter-American system does that as well. But that comes from the regions. The regions meet in different places, and now that idea found its way to Geneva. So I think those are two examples of where regional ideas are picked up and find their way then to the global one. Thank you.
Thank you again for those examples, and I think those are also examples to, well, get to a closure of this conference with. I think substantively also, and that was mentioned before, we see a norm development in terms of collective rights, right to environment, right to development in regional systems that are slowly moving into the global system. So I think there is also definitely development that is being discussed. So to all of you panelists, thank you very much. If there is, I see there is no questions anymore in the chat. If you would like to share some final views still in that session, please let me know before I get to the closing of this session. So then I would, yes, please, Ms. Motak. Please unmute your microphone, sorry.
Yeah, I wanted to answer to the question that was raised to us, and how we reach the public. I think this is something very that maybe at the level of the court we don't have enough awareness about awareness we have, but maybe we don't have enough mechanism to reach the public. We have the legal language. What as a mechanism, I think this is easy. Maybe you have press conferences at the Human Rights Committee and other treaty bodies, and as special rapporteur, I think sometimes you really you reach the public. You have to be there on the ground and to speak with the victims very often. So this is a way that you get what I found very important for the application of the human rights. Very, very important. You get the empathy with the victims of human rights. This is not just a word, but if you don't have an understanding of the people who live in a country and that and also of the victims, I think it's everything will be empty. So this is to put the connectivity. I think this is another reason why it's so important for different regional and universal body to move toward so many countries that it's possible, because this will give the opportunity to have, if you can have, because it's very difficult to have, but to develop eventually this empathy that is crucial from the connectivity, I think. Thank you very much.
Thank you very much. Thank you for that. And indeed, the empathy and the understanding, creating that connectivity will be things we'll take away from that conference here also. Thank you all very much for your interventions in that panel. Thank you for the great insights, for the discussion, also the replies that you had to each other's interventions. I think, again, as I said, we saw a lot of examples of where connectivity is taking place in a very positive sense. We also will recall what was said, I think now by Christoph also, about the interpersonal dimension of that also, in terms of how you can work well sometimes across systems with people you already know, and you develop the personal dimension. I hope also that the Geneva Human Rights Platform can be a possible place for informal exchange among the people really working in those mechanisms, among all of you, and to foster actually the connectivities. Obviously not to replace, not at all, rather to reinforce the official exchanges that you're having, that you mentioned also, but again, to strengthen that say interpersonal dimension also of the connectivity between the mechanisms. Now, drawing the conference to a close, I would like to thank again you, but also all the speakers of all the other panels, the institutions who co-organized all those panels with us, and obviously the team at the Geneva Human Rights Platform, Domenico Zipoli, Charlotte Day, Yasmin Arias, Tatiana Avante, and also Natalie Nivelas, who has been tweeting during the meeting, our communication colleague. And I would like to thank Switzerland for the support to the Geneva Human Rights Platform and this very conference. Next step for us will be, well, to think about all the points that have been discussed today, and to prepare a short report with takeaway points, with action points actually, for inspiration for our own activities in 2021, but also I think points that might be reminders to you all who participated. And I hope therefore also that the most important outcome of that meeting could be that you individually and in collaboration can take something useful for your work, helping to enhance the collaboration and connectivity among the various human rights mechanisms into more or less one joint system, with obviously the different documents, with the different sources, with the different specificities, but to enhance really effectiveness and implementation and realization for human rights for all. With this, I would like to close this meeting. Thank you all very much for your participation in this very specific hybrid setting, and maybe in next year's annual conference we'll be all able to meet all in person in Geneva. So I'm looking very much forward to that already as well. Thank you very much, and have a good day, evening, morning, wherever you are. Thank you, and goodbye.